conferees, please, if you are going to contribute, we would like it to be very snappy. We'll take like 10 contributions if possible of 1 minute each. Thank you very much. Let's have a good session. Isaiah Bozimo, young, hardworking, erudite former Attorney General of Delta State, will be our lead presenter. Isaiah, you have the floor. Thank you very much.
Thank you very much indeed, my leader and my boss. Distinguished senior advocates of Nigeria, distinguished colleagues, ladies and gentlemen, good afternoon. So, I would like to begin with a short story that really sets the scene as to the discussion we're going to have today on transforming legal practice in Nigeria. And if I could just ask the organizers to please bring up my slides. Thank you very much indeed. So, just a few months after my birth in 1981, there was an environmental case that occurred in Delta State, environmental tragedy that affected 4 communities in Delta State. And the year was about 1982. I was a few months old. And these 4 communities were about to engage in a very protracted legal battle. The main protagonist, SPDCN. They were involved in an oil spill, and the consequences were quite severe. At the time, I was blissfully unaware of the legal marathon that was about to ensue. So, in 1983, just after I crossed the threshold of my first birthday, I was born in 1981, my parents initiated proceedings on behalf of these 4 communities, and the fight was taken up at the High Court of Bendel State, as it was then. About 14 years after that, the High Court of Delta State gave judgment in favor of these 4 communities, awarding about 30 million naira in damages then. Then I was about a teenager. I started to understand the intricacies of the legal and the justice system. But this battle was far from over. SPDCN, undeterred by their loss, appealed to the Court of Appeal, and another 3 years would pass. The Court of Appeal affirmed the High Court's judgment, but there was a further appeal to the Supreme Court of Nigeria. Now, in 2015, then I was 33, 34 years old, I argued the case at the Supreme Court. So, essentially, at about 34 years of age, I was addressing a case that began when I couldn't even speak. Now, the Supreme Court dismissed the appeal, and victory was ours, but at what cost? By the time the Supreme Court gave its judgment, 33 years had passed since the cause of action. 75% of the original claimants were deceased, and about 88% of the value of the naira had depreciated. So that 33 million naira that was awarded in 1997 was virtually dissipated. So what does this long and complex journey tell us? It exposes a glaring problem at the heart of our legal practice. It shows that our problem is not access to justice, it is actually exit from justice. You can access the courts very easily. To exit the courts is another problem. And that is the embodiment of that phrase, justice delayed is justice denied. So today our conversation highlights these issues and, more importantly, proposes solutions to champion reform and imagine a better future for the administration of justice in Nigeria. And on this journey, we will examine a few things: where we are, where we want to be, and how we get there. So let's have a look at the current state of legal practice in Nigeria. Now, before I commence, I should say that self-reflection is often a very difficult thing. It can be unforgiving. But we can only chart the path to a better future by honestly looking at our current state. So with this in mind, I present to you not as an indictment, but as a rallying cry, the stark realities of the Nigerian legal practice as experienced by Nigerians. Now, I'd like to turn to a poll by NOI, which took a survey of Nigerians just like me and you. And the survey was on the satisfaction with the justice system. And 63% of Nigerians said that their experiences with the justice system was negative. Now, don't look at it as 63%. This actually represents millions of Nigerians, each with a story, each seeking justice, and each finding the system wanting. Now, what were the main causes of this dissatisfaction? The first one, as many of us can imagine, was the perception of corruption. And I should emphasize that it's corruption not with the learned judges, but corruption with the system, perceived corruption with the system. And what the respondents thought was that they felt justice was being sold for money. Now, that perception, we must take it seriously. The perception of corruption erodes faith of our citizens in our justice system and widens the chasm between the law and those it seeks to protect. It starkly contrasts with the ideals that we strive for, which is a system where justice is dispensed equitably, irrespective of socio-economic status. The second issue was one of delay, the bureaucratic red tape resulting in delayed proceedings and incessant adjournments. Like a slow-moving clock, the wheels of justice turn at a pace that frustrates the quest for timely justice. And some of us in the room might be aware of one of our retired justices of the Supreme Court that gave expert testimony in the United Kingdom and actually gave evidence that the wheels of justice in Nigeria turn very slow. It was a case called IPCO versus NNPC, where there were enforcement proceedings that were about to take place in the UK, and there were awaiting proceedings to be completed in Nigeria. And a justice of the Supreme Court gave evidence that the wheels of justice turn extremely slow. So the endless wait for verdicts and the crippling backlog of cases, the resultant inability to exit the justice system are vividly captured in that case I told you earlier, and that case is the one of Joe Lanaro versus SPDCN. It serves as a poignant reminder of the high costs of delayed justice. Again, the NOI poll asked Nigerians to rate our justice system on a scale of 1 to 10, 1 being very poor, 10 being excellent. How do you rate the system? The response, 4.25. So that's subpar. And now, this score, to me, is a wake-up call. It's a compelling call to action, and one we must heed to, not with resignation, but with resolve. The glaring issues within our justice system presents both challenges and opportunities. Opportunities for reform, transformation, and evolution that can usher in a new era of justice administration in Nigeria. They call us to seek inspiration and learn from the experiences of other jurisdictions that have weathered similar storms. So as we move forward in this discussion, let us consider these realities. It is only by facing our challenges head-on that we can hope to foster the necessary changes that we seek. So our task now is to examine how other jurisdictions have approached these challenges and draw lessons that guide us in reshaping the future of legal practice in Nigeria. So let's have a look at lessons from other jurisdictions. So in seeking solutions for our challenges, we don't need to reinvent the wheel. Much of what I will say, you have already heard. It's just a case of implementing it correctly and with a specific purpose. So other jurisdictions have faced similar issues and have embarked on innovative paths to reform. By studying these examples, we can gain insights and ideas to transform our legal practice. So first, let's turn our gaze Southeast Asia to be specific, and to the country of Singapore. Despite its very small size, Singapore is home to one of the world's most practical and effective legal systems. This triumph is not an accident, but the fruit of purposeful, continuous dedication to ingenuity, progress, and an uncompromising adherence to the rule of law. They have warmly embraced technological advances such as electronic filing and virtual court proceedings, significantly reducing bureaucratic red tape and expediting case management. Furthermore, establishing the Community Justice Center is a testament to their commitment to justice for all. And a similar example I can think of in Nigeria is the Citizens Mediation Center in Lagos State. This comprehensive, all-encompassing approach to justice reform provides valuable insights as we strive to transform in our own system. Next, we can look at the UK. Now, the UK has a history of essentially providing access to justice for all, and you can see that in the way they center their system on these principles, from efficient legal aid system, which offers state-funded legal support to those who are unable to afford it, to the innovative Lord Woolf reforms that overhaul the rules of civil procedure to ensure timeliness and cost effectiveness. Essentially, what those reforms did was to shift the balance of power from council to the court, and I'll speak more of that as I go on in this discussion. Closer to home, we can look at South Africa, our continental peer. Their transformative approach to justice reform is both inspiring and instructive. And I look in particular at the Constitutional Court of South Africa, which is the highest court of the land, and which represents a resolute symbol of the country's commitment to democratic values and human rights. That court has become a catalyst for societal transformation and the promotion of equity. Now, while each of these jurisdictions is unique in its journey, they provide us with invaluable lessons. They serve as an affirmation that the task we face may seem daunting, but it's far from impossible. They are a testament to what can be achieved with the right blend of resolve, innovation, and adaptation. So as we contemplate these examples, we mustn't view their solutions as blueprints that we just take and copy verbatim. Instead, we should be inspired to customize those solutions to align them with our unique Nigerian context. To borrow from the wise words of revered Nigerian author Chinua Achebe, it is the storyteller who makes us what we are, who creates history. The storyteller creates the memory that survivors must have, otherwise their surviving would have no meaning. So in this regard, we are the storytellers of our legal system. We carry the power and the responsibility to shape its future narrative. Let these examples from other jurisdictions inspire us to rewrite our story, transforming our legal practice from what it is today to what it can truly be. So in the next part of this discussion, I'd like to explore reforms that we can use to address the issues that are plaguing our justice system and can catalyze the transformations that we seek. So let's envision the future of Nigeria's legal practice. So the journey we have embarked on today invites us to envisage a bold, daring future, where our legal practice is not simply a functioning system, but an exemplary one. Now imagine, if you will, a justice system in Nigeria that is universally respected and trusted. A system where every citizen, regardless of social status, financial means, is confident that they will receive a fair and impartial treatment. This is a future we can aspire to, and one we can and must achieve. In our desired future, the courts would be revered sanctuaries of justice, embodying the democratic ideals that we uphold. There would be places where disputes are resolved swiftly and equitably, without delays, and without unnecessary adjournments. Unnecessary adjournment should be a thing of the past. How do we get from where we are to where we want to be? Now, I think with the right mix, we stand on a precipice of great transformation in our legal profession. Our envisioned future, where justice is not only sought, but delivered timelessly, equitably, and efficiently, is a journey. And today I'd like to discuss a roadmap to this future drawn upon three cardinal pillars: proactive legal policy reform, the adoption of technology, and a renaissance in legal education.
I am proposing a broad-based training which enables lawyers to develop the expertise to deal with concrete problems of society rather than mechanical subservience to procedural technicalities, which I consider to be strong imperative. We must give ourselves to learning. That's the point I am making. Not just reading law books, but reading classics and other literatures. This is very important for us if we desire transformation in legal practice. Learning does not end with legal education, which the Faculty of Law imparts to our students. I'm happy the Dean of Law of Bayes University is also here with us. So learning does not only end with legal education, which the various universities are doing, nor the practical learning which we learned from the Nigerian Law School. An advocate in legal practice must have an unending urge for acquisition of knowledge and for its updating, as we are doing here in this conference. It is not enough for the lawyer to know where to find the law. He should rather know the law itself by acquainting himself with the fundamental principles of the law. Let me add that the learning process continues in the courtroom. I learn a lot from good bar advocates who appear before me. Every lawyer, no matter how experienced he may be, learns something new every day in the courtroom, either through the proceedings in his own court or in his own matter, or from some other person's case. You also learn something from it. Now, I'd like to address 3 or 5 issues that I will raise. Hey, my chair. I'll be the one to ask for extension of time. Okay, just 2 minutes, then I'll be done. What are the pivotal skills or equipment that a lawyer will need if he desires transformation? I have noted here that the lawyer needs curiosity and inquisitiveness. He must be able to, the ability to apply his knowledge of the law to the facts of the case. A good lawyer too should be able to be a good researcher and be a patient reader. Creativity and legal thinking is also important. You must know and understand what to ask from a judge before the court and the basis upon which what you are asking, whether it is one that can be granted. As judges, we shall, however, wait for those of you who appear before us to assess the extent to which you positively exploited the opportunity this conference has offered you. I have exercised the jurisdiction you conferred on me, and I say thank you.
Thank you very much, my Lord. You presented the paper in the same forceful manner you deliver your judgments. We thank you very much. There's a lot of food for thought from what you have presented, and I'm sure there will be engaging questions from the other side, because as the lead presenter has said, both parties have a role to play. The lawyers, who you have said we need to retool and reskill, and the court itself. It's unfortunate, but now I have to call on Professor Agbomadaki. You know, people that deliver lectures, who deliver lectures for 4 hours, 5 hours, to now call him and say, make a contribution in 10 minutes. It's like I'm giving him poison, but I'm sure that Agbomadaki will understand that my hands are tied. All right, thank you. You have 10 minutes, and your time starts from when you pick up the microphone. Thank you.
Minus saying hi to you. The President of the Nigerian Bar Association, the Chairman of this session, distinguished panelists, ladies and gentlemen. I chose to stand because I'm told that the next smoking is sitting. when you sit for too long, the health implication is as bad as smoking. My little contribution to this very exciting and interesting discussion, which relates to transformation of legal practice in Nigeria, especially in the light of technology and development, I'm going to speak very briefly on just 3 thematic areas of the conversation: globalization, technological advancement, and shifting societal expectations have significantly impacted legal practice. And to keep pace with this transformation, it is essential to reassess legal educations and training in Nigeria. And therefore, I will be speaking to these issues. The advent of technology has revolutionized legal profession worldwide, and Nigeria is not an exception. Nigerian lawyers must embrace digital tools to improve efficiency, enhance access to justice, and streamline legal process. Electronic case management system, online research database, and virtual communication platforms are examples of technology reshaping legal practice. A little bit of comment on globalization. Globalization has increased cross-border transactions, necessitating familiarity with international legal framework and practice. Nigerian lawyers should therefore possess a global outlook and understand the nuances of international law, trade, investment, as the case may be. The truth of the matter, we have our, before now we have BMAS, now we have the core content maximum academic standard. And when we get, after being called to the bar, you realize it's a totally different ballgame. So I think it is very important for continuous legal education among our lawyers, either through the various MBA program or conferences like this or postgraduate studies. The next issue is the evolving societal needs. The truth of the matter is that we have a much more enlightened society, and with the different apps that we have a lot of people that can actually punch their system and come up with construction agreement, legal agreement, as the case may be. And we now have clients that are in a position to challenge attorneys or lawyers, as they may be called, onto the content and quality of their job. So the needs and expectations of society are evolving, demanding more responsive legal services. Nigerian lawyers should be equipped with skills in alternative dispute resolution, negotiation, mediation, and non-adversarial methods in order to promote efficiency, reduce litigation costs, and foster access to justice. How about the trainings that lawyers receive in Nigeria? Law schools in Nigeria must integrate technology-related courses into their curricula. Courses on legal tech, e-discovery, data protection, and cybersecurity should be offered to equip law students with the skills needed to leverage technology effectively in their practice. And I'm able to say that I'm not just suggesting this, we are doing that very much at Bayes University. I'm sorry, may I acknowledge the law students from Bayes University? There are about 50 of them here. I recognize you. I appreciate the sacrifice you've made coming here, leaving your lectures to be here. Thank you very much. I do hope you leave here with something. While traditional legal principles remain essential, practical skill training should be a significant component of legal education, like muting, legal writing, client interview, negotiation, and advocacy skill must be developed through interactive teaching method, including mock trials, clinical programs, and internship. The truth of the matter is that because of the quality, content, and context of legal education, both at the university level and even the vocational training at the law school, our young lawyers are actually ill-prepared to meet the changing challenges of the society. And that is why a lot of law firms either find it very difficult to engage them, or even when they engage, they offer them very little salary, believing that you're actually training this lawyer, and that ideally they are doing privileges and they ought not to be paid. So what I'm suggesting is that our law faculties should go beyond the traditional law courses that were taught many years ago and move ahead with what is happening in the society. I'm glad to inform all of you that the National University Commission has altered and introduced a new curriculum for Nigerian University, which is called the Core Content Minimum Academic Standard, which now allow individual universities and faculties to contribute 30% of what they think the students should be taught for all courses. That is, you add your own local content. So I do believe that there's going to be a lot of changes very soon. Also, it is important to expose our lawyers to international perspective. Therefore, law schools should foster a global mindset by offering courses on international law, comparative law, global legal framework, encouraging student exchanges, internship at international law firm, and participation in international mute court competition can expose Nigerian law students to diverse legal systems and practices. Currently, there's what we call the AAA matrix. For those of us in academics, we go on sabbatical. The truth of the matter is that oftentimes when we go on sabbatical, it's an opportunity to earn an extra income. While you retain your income in your university, the other university will pay. But I am suggesting that both for the legal practitioners and for those of us in academics, we must take sabbatical to a next level. For instance, if you are a law teacher teaching commercial law subjects, why don't you go and take your sabbatical in the law firm of Aluko Yobode or Osi Alege and Company and practically experience what it is to be involved in commercial law practice? There's nothing also wrong for those of us in private practice to probably even 3 months of the year and go to a firm that you know that they are offering services that you are not offering and learn, or even go outside the country. There are firms in America that have over 300, 400 lawyers. And I think it is time that other than continuous legal education, legal practitioners in Nigeria should also think about the idea of going on what I may call legal practitioner sabbatical to other bigger law firms where they can improve on their skill. Now, what is the implication for law teachers and students? Law teachers must involve more knowledge. Law teachers must evolve from merely being knowledge disseminator to facilitators of experiential learning. They should incorporate innovative teaching methods, including case studies, simulations, and group discussion to encourage critical thinking, problem solving, and practical applications of legal principles. What do I have to say for the students as an active learner? Law students should take an active role in their learning process. They should seek practical experiences through internship, pro bono work, and student organization, active engagement with legal technology, research and professional network, and enhance their skill and prepare them for evolving legal landscape. What we are doing in BASE, since I became the dean, is to bring people with industry experts, to be involved with the student. And because of that program, last year we engaged Professor Ebe Kachiku, one of the best brains in the oil and gas industry, who is now a visiting professor in Nigeria. As I speak to you as of today, Dr. Duroti Ufot, one of the best arbitrators from Africa, we have also convinced her and engaged her as a visiting professor to BASE University in order to enhance our postgraduate studies in international arbitration. Then mentorship and networking. Law teacher and legal professionals should mentor and guide students and younger lawyers, providing career advice and helping them develop professional network. Mentorship program and alumni engagement can facilitate knowledge transfer, promote collaboration, and foster supportive legal community. My conclusion, the transformation of legal practice in Nigeria, they state a comprehensive approach to legal education and training. Nigerian lawyers must be equipped with both traditional legal knowledge and contemporary skills to adapt to the evolving sector. Law teachers play a critical role in imparting these skills, fostering critical thinking and facilitating experimental learning. Law students must actively engage in their education, seeking practical experiences and continuous professional development. By embracing these changes, Nigerian lawyers can effectively serve the need of a rapidly evolving legal landscape. Thank you very much.
Professor Agbo Madaki deserves more than just that little round of applause. Very thought-provoking paper, and I believe we will also have some interactive questions that we will have to answer. For now, we'll go back to the judiciary. I want to call a man who is not tired, but has only just retired, Honorable Justice Taiwo, to give us his own 10 minutes presentation. Justice Taiwo, please.
Thank you very much. Well, I don't want to waste time. People have been greeted. Hello, everybody. Is all I'll just have to say for now. I'm very grateful to the organizers of the conference for inviting me. It's a way of engaging my brain. I'm retired, yes, but I don't have to sit down in the house doing nothing. I must not be seen in 2 years' time after my retirement working with walking stick and not being able to even remember the name of Austin Alege, who I served as second vice president of the NBA. And I stated that I'd always been in legal practice. Since I was called to the bar in 1983, I never mixed it with any other business. So you can understand my passion. Never, unlike some people I know, even amongst us here, that have been able to blend contracts, with law. So my passion is the law, and my passion is Nigerian Bar Association. Now, I went into the case of Atake against Afejuku to determine the term practice of law. It's a Supreme Court judgment. I'm not going to read it. Then I said I was in and out of court at a period when there was nothing like written addresses in lower courts. The advantages of written address are enormous, one of which is the fact that judges no longer need to take down everything read out by the counsel verbatim. Advocacy thus became written rather than verbal. I want to quickly state that the evolution of written addresses has not entirely cured what we all envisage, in view of the fact that many lawyers still want to talk in adumbration, their legal positions, and they go on to repeat what they have put down in writing, most oftentimes to impress their clients if they happen to be present in court. This, in effect, wastes the time of the court, especially in cases where different counsels appear for different clients in a case. Again, the judge ends up writing in longhand these submissions. The counsels at times insist on being recorded, and a refusal to do so by the judex leads to disrespect in words and indeed by the counsel, leading to unpleasant exchange of words by the court and counsel. It has happened to me. And I'm sure Justice Kio knows what I'm talking about. We must not lose sight of the fact that there is a dearth of court recorders and recording equipment to assist the court in the discharge of its duties effectively. Technology is yet to be deployed to assist in decongensing the courts and making lighter the workload of judges. I know this, first as a lawyer in practice and as a judge of the Federal High Court of Nigeria, which I can conclude is as one of the busiest courts in Nigeria today because of its jurisdiction as stated in section 251 of the 1999 Constitution of the Federal Republic of Nigeria as amended, and in other laws and statutes which confer special jurisdiction on the court. The paper presented epitomized the experience of the presenter in litigation. His experience in the protracted case of Shell Petroleum Development Company of Nigeria Limited is one of the many cases I experienced, true in practice and on the bench. I had the honor of concluding one of such cases involving Shell and the Ogonis, decided by my Lord Justice Buba, now retired, in 2009. years before I became a judge. The case went all the way to the Supreme Court with the affirmation of the judgment of the Court of First Instance. However, the judgment debtor did not pay the judgment sum until 2021. After I insisted, you know what I did in that was that the case was transferred from one judge to me. And I looked at the enormous files, a case of almost 20-something years. Where am I going to start from? And I looked at, they had a lot of applications in the file, a case that I'd gone to. I said, okay, I'm not going to listen to any case or any application. What the problem was the issue of the payment. That is the interest element, which has gone up to about 120-something billion. So the judgment fund was 19 billion initially. What I now did was that I asked the judgment debtor, I first of all asked all parties to see if they could come to terms. They did not. On the next adjourned date, when they came back, I said, okay, judgment debtor appoints an accountant, creditor appoint an accountant, and I made the president of the ICANN the president to sit on the committee to determine the issue of interest. I hope that's not for me. To determine the issue of interest. So they went away. They did not even meet. They all agreed because I subtracted whatever was paid or had been executed from the initial sum, leaving the balance of 17-point-something billion. But I must say that I had before me a crop of very seasoned senior advocates, about 5 of them in number. They went away. By the time we went on vacation and we came back, they have agreed and they settled for 52 billion naira. I never touched a single application in that file, and that was the end of the case. Thank God I decided it and I ended it. Now, another one is a case that happened in my chambers. I became a judge in 2015. We started this matter in 2014. When I retired in 2022, the case was still pending in the High Court of Lagos. When I now go back to the office as a consultant, because my daughter took up the law firm, I now said to myself, what am I going to do here? So we entered into negotiation. We agreed. On Monday last week, they signed the terms of settlement, but with this very unfortunate situation. At the time we started the matter, the defendant ought not to have he ought to have just paid the 14 million we were asking for. When we settled last week, he had to cough out 100 million in full and final settlement because he had no business coming to defending the case in the first place. In fact, his lawyers ought to have advised him of the futility of his coming to court because it was very clear, very, very clear. And, well, I said I agree with then another thing is getting dates from the courts. When there were 2 matters, I had to personally go to the Court of Appeal, Lagos, to try and see if we could get it. What was delaying it? And in these 2 cases, the appellants had not filed briefs for over 2 years, which would have made it very easy for the judges to just dismiss the matter. We filed an application. They filed an application before I got there. The application is yet to be heard as I speak. No date yet. We are still waiting. We will still continue to wait. We will get there one day. Anyway, I equally agree with the presenter that incessant adjournments cause delays. Let's face it, lawyers engage in the practice of asking for adjournments to either delay a bad case or for the purpose of, in quote, putting their house in order. When senior lawyers want to engage in it, they will send a junior in chambers who comes and tells the judge that the learned senior counsel is personally handling the matter and such another date is required for him to attend, after giving an excuse that most times is flimsy. Most times the court has no choice than oblige in the interest of justice, since the court is not to shut out any party. We tend to forget the decisions of the Supreme Court that a counsel from a law firm handling a matter is deemed to be conversant with the file and must therefore go on with the case. I'm of the view that judges must insist that the case must go on except the other party is not ready. We forget that justice is for both parties and not a one-way traffic. Lawyers seem to be too combative in my own analysis from experience at the bar and the bench. We don't give clear-cut advice to our clients, and most often than not, in practice, the advocate cries more than the bereaved. Cases are taken too personal, and this should not be so. Personal ego does not enhance justice and its delivery in the final analysis. On the issue of adjournment, the court cannot be entirely exonerated. Judges attend conferences, seminars, and get assigned matters, which prevent them from sitting at times for months on a regular court. A case in point is the withdrawal of judges all over the country for election petitions. Some may finish on time, depending on the number of cases they have to deal with, while others may be out throughout the period when the courts are in session. The normal cases in these various courts therefore suffers. I agree with the erudite lawyer of repute, one of the leading lights of this profession, Are Afe Babalola, Senior Advocate of Nigeria. Correct me if I'm wrong, if it's OFR or CFR, when he proffered recently that retired judges should sit on election petitions. Well, the Constitution and various laws need to be amended in order to change the narrative. Again, from the bench, I see no reason why bench rulings will not suffice in certain cases. In this category, ex parte applications that are not contentious. I also agree that judges should be proactive. Why should I adjourn to give ruling on an ex parte application for extension of time or amendment of pleadings, when it's either it's your discretion to agree or not agree? If you see that I'm not going to agree, why don't you do it there and then instead of adjourning for another three at times a month to deliver a ruling? Yes, I agree that the Constitution says you must do so at a certain time. But for us to be proactive, we have to make sure that we use our own discretion to make sure that the wheels of justice roll without any impediment in any form. Anyway, then I want to set a case. A counsel informed me that he had an ex parte application to serve out of jurisdiction. This was one day I wanted to clear the court of many lawyers who were sitting. He said he wanted to serve out of jurisdiction in Niger State. I informed the counsel, citing Akeredolu against Abraham, that he does not need my prayer to serve out of jurisdiction. He disagreed and informed me that it was an important matter and therefore urgent that I add it. I then told him to go ahead and serve, that I will endorse it in my records, reaffirm that I asked him to do so. I stood my ground. He went away sulking, but I refused to even acknowledge his men. The next thing he did was to write a petition to the chief judge. On receipt of the petition, I not only responded, I sent back the file for reassignment. In a criminal matter, after the defendants failed to move the court successfully on a no case, they engaged another lawyer who cunningly wanted to reopen the case. He filed an application to recall a witness. I refused. He then filed an application challenging the appearance of the prosecutor who was handling the case before he retired, but was given a fiat to continue the prosecution of the case in his personal capacity. I refused the application. He should know that I came from the bar. I'm not just anybody that was appointed without my experience. I came from the bar. And I can't, before you say anything, I know where you're going. We all know the tricks. So if you play the tricks, I know how to give you the other one. That was what I was doing. Anyway, I refused the application, so the counsel, using his clients as a shield, the hands of Esau effect, wrote a petition to the chief judge alleging bias on my part. In the petition, I was accused of many things, one of which is that his client, during his evidence in chief, was telling cock and bull story, whatever that means. I remember that what I said was that his evidence was unwinding and unnecessary. He was actually telling me stories that looked like fiction. The whole purpose, I'll be done. The whole purpose was to cause a delay, knowing fully well that I was retiring. I asked him to file a proper application to show why I should recuse myself from the case after taking all the witnesses for the prosecution. He did file one, and I refused it in very harsh words for the counsel. He achieved the same anyway because I retired before further hearing. In another scenario, a senior advocate actually asked me to descend, to come, if I can come down from the bench to ask questions of his witness during cross-examination, because I was telling him that the issue of venue of commission of an offense is a matter of address, not for cross-examination. Everybody knows that, but he refused. That day, thank God, I'm not on record, that, well, depending on the way you look at it, I was going to commit the senior advocate for contempt. Really. If not for the very senior lawyers that were in court, they came and interceded. They knew what he did was wrong, and then I accepted their apologies. Political matters are rife with this type of things. They delay. They would just get somebody to go and... There was a time they said I was friendly with a governor that I'd never even met in my life, just because they didn't want the matter to go on. So, Mr. Alige knows the case I'm talking about. Anyway, I will now say that in conclusion, I said the issue of ethics should be taught right from university. We need formal and informal education. We must strive to lead by example the upcoming generation of lawyers. We should rise above description of lawyers by Jonathan Swift in Gulliver's Travels, when he stated thus, I quote, "They were a society of men bred up from their youth in the art of proving by words multiplied for the purpose that white is black and black is white according as they are paid." End of quote. It is high time to enforce the rules of professional conduct in the legal profession to the letter if we really want to transform legal practice in Nigeria. The Nigerian Bar Association must deploy disciplinary measures to arrest the pollution of legal practice by the bad eggs masquerading as lawyers, when in fact what they crave is money, using the toga of being a lawyer as a shield. All hands must be on deck. I'm of the view ethics of the bar should be taught from the universities before the law students enter the law school. The transformation we need can be achieved if we can clear the rot in the system, which the paper highlighted. After all, the rules of professional conduct is not a paper to be overlooked. Its purpose must not be allowed to die. Thank you.
Thank you, my Lord DT, for your very passionate, erudite, and deep presentation. We thank you for your tour of duty. And we remember that we started the tour of duty in MBA together in 2014 before you ran away and left us and went to judiciary. But we are happy that you have gone and you have come back. I'm proud to say that you represented us very well. Thank you very much again for your presentation. Yes, we will permit you. We will. It's now time for the former Attorney General of Sokoto State, Usman Suleiman, Senator of Nigeria, to give his own intervention. We have eaten into our time allocation a little bit, and what we have decided to do is that we'll take Professor Shiroma last, and he will give his presentation and immediately address his bite-sized series before we shut down. So we now want to get the very deep presentation from Suleiman SAN. You have the floor, sir.
Thank you, Mr. Chairman.
And it's for 10 minutes on the dot. You know,
Thank you, Mr.
Justice
Chairman.
Taiwo is from judiciary. My hands were tied. But me and you, we are together on this side.
In view of insufficient time, I stand on already established protocols. I begin by saying that legal practice in Nigeria has undergone a lot of transformation over the years. The transformation of legal practice has been influenced by factors including globalization, advancement in technology, the increased need for legal services, international transaction and dispute, technological advancement, changes in legislation, and the need to align with international best practice. This has also led to the emergence of law firms and lawyers who specialize in cross-border legal practice. Nigeria has adopted international best practices, and Nigerian lawyers and law firms are increasingly aligning their practices with global standards, such as those set by international law firms and legal organizations. These include adoption of modern technologies, improving legal research capabilities, and enhancing the quality of legal services. The liberalization of legal services has led to the facilitation of legal knowledge and expertise between local and foreign practitioners, leading to development of more internationalized legal profession. The growth of international trade and investment has created demand for legal services that transcend national borders. This has resulted in specialization of Nigerian lawyers in such areas as international arbitration, cross-border transactions, international trade law, among others. These specialized practitioners are equipped with necessary skills and knowledge to handle complex legal issues that arise in global context. Transforming legal practice in Nigeria towards a more globalized and borderless approach has brought numerous opportunities for lawyers and law firms. It has expanded its reach, increased the diversity of legal services available, and enhanced countries' overall quality of legal practice. The expansion and transformation of traditional legal practice to a global scale enable lawyers to work with clients and handle cases in different jurisdictions. One of the key transformations in legal practice in Nigeria is the adoption of technology. Lawyers are now embracing online and digital platforms, legal software, and document automation to make legal services and processes more efficient and accessible. For instance, the introduction of e-filing has simplified the process of filing court documents, reduced paperwork, and saved time. Additionally, online platforms such as Law Pavilion, Legalpedia, etc., have made information more readily available to legal practitioners and the public. The adoption of technology will continue to play a significant role in enhancing access to justice and improving delivery of legal services. Some obstacles to successful technological adoption in the legal profession in Nigeria include: one, limited awareness and understanding, because many of our legal practitioners are still analog. They are not ICT savvy, and there's a need to promote awareness and education about legal technology through workshops, seminars, and trainings such as this. Collaborate with legal associations and organizations to provide resources and training opportunities for legal practitioners. There's also resistance to change. Resistance to change is a common factor and obstacle in any sector, including the legal industry. Some professionals hesitate to adopt new technologies due to fear of job displacement or unfamiliarity with new tools. We need to embrace change and the future, otherwise it will be in a rush shock when it arrives and will be left behind and left out completely. The solution is to increase, highlight the benefits of technological adoption will increase efficiency, improve client service, and cost saving. It provides and provide training and support to help legal professionals to adapt to new technologies and demonstrate how these tools can enhance work rather than replace it. There's also the issue of limited infrastructure and connectivity because of lack of robust internet facilities throughout Nigeria. And also we have issues of energy. So we advocate here for improved infrastructure and connectivity in collaboration with government and private stakeholders. There should be encouragement in investment in reliable internet service and we should develop technology hubs and centers in different regions of the country so as to have the needed infrastructure. There is also the issue of data privacy and security concerns. The legal sector deals with sensitive information, especially confidential information, which raises concern about data privacy and security when technology solutions are adopted. To address those concerns, there is need to enforce data protection and privacy laws, encourage legal professionals to adopt secure technology solutions, and provide training on data security and best practices. Collaborate with technology providers to develop solutions that prioritize privacy and security. There is also the cost consideration when it comes to technological adoption, and this will involve upfront costs, which may be a barrier to some legal professionals. If partnerships are explored and collaborations are made with technological service providers, there will be affordable and discounted solutions for legal professionals. We also need to advocate for government support for incentive to assist professionals in adopting technology and guide cost-effective solutions. Another aspect of legal transformation that we have witnessed is the impact of artificial intelligence and machine learning tools in the way legal services are provided. And this has transformed and led to breakthrough in the use of AI technology. For instance, in Law Pavilion, we have Timmy Law, which is a chatbot that enables legal practitioners to seamlessly research for legal solutions and legal principles and cases. There is also the legal analytics, which is one of those areas where AI has impacted on the legal research and thereby improving efficiency and reducing costs of providing legal services. Transformational legal practice has also led to specialization in special areas of law and also the creation of specialized court. In areas of legal specialization, for us to practice in a borderless manner, we need to imbibe specialized legal knowledge. Apart from being interdisciplinary, by imbibing interdisciplinary legal scholarship, we need to have knowledge in international business law, international dispute resolution, international law, and also knowledge in ICT, so as to be able to practice at an international level. Regulatory reform also in Nigeria has also transformed the way we practice law. For instance, the electronic evidence has been brought to the fore and has now been integrated into the way we present evidence in court, courtesy of Section 84 of the Evidence Act 2011. Another notable example is Administration of Criminal Justice Act 2015, which contains provisions for automation, creation of database for keeping records and tracks of all suspects, as well as e-filing of criminal charges and criminal processes. Regulatory reforms that promote innovation also must be pursued so as to remove unnecessary restrictions and allow for alternative business structures and facilitate the entry of, here I'm talking about the incursion of multidisciplinary practice. There are incursions of foreign accounting firms that have presence in Nigeria, and they are practicing law apart from advocacy, and there is need for regulation here. The Nigerian Bar Association need to be in the forefront to ensure that law firm regulation is heavily entrenched in Nigeria. Another aspect that has also transformed the practice of law is alternative dispute resolution. That is one aspect now. Our law firm must not just be for litigation, but must be ADR based. We must have knowledge in alternative dispute resolution, especially given the fact that with the Arbitration and Mediation Act 2023, Nigeria has joined the rest of the world to be a very good destination for mediation and arbitration, thereby already domesticating the New York Convention of 1958 and now the Singapore Convention on Mediation. Case management also need to be pursued vigorously and so as to ensure swift justice. Early assessment of cases must be done and early disposition of cases. The trend now in election petitions whereby all objections are adjourned to address level, I think need to be revisited because there are some fundamental flaws in certain cases that are manifest and need not be allowed to fester till the address stage, thereby disposing what needed not to be in the docket of courts and making people to undergo the rigors of litigation when they ought not to have undergone. Despite the improvement in the legal in practice of law due to transformation, there are still some challenges like the means of correction, backlog of cases. We know delay. We have to talk about delay all the time because it is still part of our legal practice. Delay exhausts finance, patience, courage, and hope. It breaks the heart and overthrows the brain. And since Magna Carta, chapter 12:15, chapter 40 said, to no one shall we delay or deny the right to justice. Delay causes hardship, bring our administration of justice into disrepute. It results in deterioration of evidence through loss of witnesses, forgetful memories, and death of parties. And therefore, we have to continue to create fast-track means of resolving this. We have also gap in legal education that need to be augmented. We must collaborate and encourage networking, international exposure, cybersecurity and digital practice. In cybersecurity in a passing, I would like to talk about data protection, privacy laws, and ethical obligations. In sum and in the light of the foregoing, legal practice in Nigeria has undergone significant transformation driven by factors such as technology, adoption, the need for efficiency, where there are challenges that need to be addressed, such as corruption and backlog of cases in courts. There are also promising prospects for the future, including ongoing reforms. The adoption of alternative dispute resolution mechanism, indeed a shift towards legal practice without borders, fostering collaboration and promoting international exposure, implementing regulatory reforms and improving access to justice are critical steps towards transformation. Nigeria can improve the quality of legal services, promote innovation, and ensure legal profession remain relevant. Nigeria can enhance the quality of legal services and ensure that legal work remain relevant in a globalized world. I thank you for your attention.
Thank you very much, Honorable Attorney General, before, for your very wonderful presentation. We had promised that we are going to have an interactive session and take questions from conferees, and we still intend to do that despite protestations from the organizers. But to make it fast, I will advise anybody who has any question to please write out the question, and the session coordinators will pick them up. Your questions, whatever you're writing, should set out your name, your branch, who you intend to answer the question you are asking, so that we can wrap it up. We'll do our best to wrap it up, but I do not think that all the questions that people have to ask, we will allow them go with all the questions. And we would like any person who is interested in asking to please write it out and give to the coordinators. When he gets here, we'll merge all the questions and see how we can have a fast session. Thank you very much. For all of us who were trained in the law school, if you're not trained in the law school, you may not applaud, but now we are calling the DG of the law school that trained all of us, including himself, to give his presentation, and also his bite size. Since he's doing that, he will get a little bit more than 10 minutes. Thank you. DG, thank you.
All protocols duly observed. Distinguished ladies and gentlemen, good afternoon to you all. I'm sure I've been co-opted to come and tell you what we've been doing or what we've not been doing to make sure that there's transformation in legal practice in Nigeria, and how do we make our lawyers to be competitive in legal practice without borders. Mine is going to be full of stories and a little bit of presentation. I'm sure you must have had a lot of time. What are they teaching now in the Nigerian law school? Why is this guy dressed like this, like he has not been to the Nigerian law school? Why is he dressed in a black suit and a pink shirt and is going to law office? These are questions that people ask every day. The expectation of everybody in this profession is that in the law school we are magicians. We should turn students who have been to university for 5 years, we should turn them to best of the best, while they spend only 6 months in the Nigerian law school. I think that is the beginning of it. Each and every lawyer wants the best. What they want is a ready practice material. Anybody coming out from Nigerian law school should be ready to go to court and serve them. The question is, how does law school do this when each and every law student spends 5 good years in the Nigerian university system? When they come to law school, they spend like 6 months. Of these 6 months, they have also 3 months of externship. Of these 3 months, half in the courts, the other in the law offices. People have been talking that in the last 20 years, 10 years, we've not reviewed our curriculum in the Nigerian law school. That is not the position. After every academic session, we bring academics from all the campuses to sit down and look at what are the developments in the last 1 year and what is the way forward. Are there changes in our own laws? Are there changes in policies? Are there areas that we've not been teaching in the last academic session that we need to look at? This is how things work. Rather than do a blame game, I think the issue has to do with the university system. Somebody who has been trained in 5 years, it is not easy for us to transform it in 6 months. I think that's where the problem is. The Dean of Banks University was talking about CC Mass, the new core courses mass approved by the NUC. It may interest you to note also that when the CC Mass came into being, the NUC gave the university on a platter of gold to say, take 50%, go and decide the courses you want to teach University said, no, 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 go and do it on our behalf. That's where the problem starts. That's what we call academic freedom. Decide what you want to teach, how you want to teach. Now, universities are happy. They are giving 30% to go and decide. That is not enough. It depends who is the dean, what is his own area of interest, his competencies. Whether also the dean is a democratic dean. If you don't call your faculty to discuss what courses you want to teach, you teach mundane courses that people have forgotten about teaching them long ago. It needs somebody who has the know-how, the knowledge, the openness, and the competence to select this 30%. And this is where the challenge is. People are talking about information and communication technology, how it will guide, how it will improve. It's not El Dorado. Under the COVID period in 2020, we had about 5,500 students in Nigerian Law School. And all of us grabbed the Zoom. We were happy. Students will do their lectures in the comfort of their houses. Each and every day of lecture, out of the 5,500 students, the maximum we had was 900 in a class of 5,500. Some would tell you they didn't know when the lecture took place. Some would tell you they didn't have internet. Some would tell you they were in the villages, that they had no money to buy data. I knew parents, lawyers who were sending me text messages that we should provide internet to their children who are in their own villages. These are challenges confronting each and every one of us. We are talking about universities that we've been talking about. Most of these students who come to Nigerian law school, some of them have never worn a black suit. I can tell you this. I said most. Some don't know that you need to use a laptop in Nigerian law school. Some don't think there's anything wrong in going to class. They think it's like, you can wear slippers or anything and go to class. These are challenges confronting us every day. But we can't speak. Ours is to train. What are we talking about? What are the issues confronting us in this our own profession? Increasing number of students in the universities. Each and every university in Nigeria has a quota. What happens every year? They keep on telling you that Nigerian law school cannot accommodate everybody. It's not true. There was never a time, anywhere, any faculty would tell you that their students were not accommodated. They over-admit. When their quota is 50, they admit 200. When it is time for admission, they go to National Assembly, they write letters, harass us, thinking, these are the issues. When you are asked to teach 50 students, you have 200 students, it's a challenge. There are universities that have 600 students in their own classes. How do you impact knowledge? How do you impact knowledge, values, and skills on 600 students? Lack of teachers also. People say there are a lot of teachers with PhDs, masters who are teaching. Teaching is a vocation. It's not a job. Most of us are not teachers. They are there by default. They've been looking for a job. They finished their own first degree. They are somewhere, somebody is doing a master's program, and you pay 80,000 naira to do a master's program per session. They go and enroll. They got a master's degree. Do the same thing for a PhD. Then somebody is advertising for a job in the Nigerian university system. They apply. The university is desperately looking for a teacher. Teaching is not a job, it's a vocation. You must have an interest. And that's why we have challenges. Merely because somebody has a PhD or a master's in teaching in the university, is not a teacher. So whatever is done in the university system, that's what is brought to Nigerian Law School. It is difficult for us to change these things. Things like habits, things like dressing, knowledge they are acquired, that is it. Then, issues of also funding in Nigerian university system. I'm sure some of these deans who are here can tell you that their libraries have not been funded for many years. You can't give what you don't have. You need to have a modern library. This information and communication technology we are talking about, also you must have databases, Nexus, Lexis, Hein Online, Nigerian Weekly Law Report on your fingertips. I can tell you that Deans will tell you the last time their libraries were furnished were many years. VCs are interested in something different. They have been grappling with lack of funding, multiple faculties, departments, and what have you. So basically, garbage in, garbage out. Those who are coming there, we do the best we can. And by nature, there are students who are bright. They'll do the best they can to pass examination. You've asked them to drive by a charge. They'll do the best, get a 40, 40, 40, and pass by examination. The challenge now is, how do you practice this profession? Somebody has advertised in a law office, they are looking for a good lawyer. You go there, they ask you certain questions you are not in position to answer. They give you an assignment to do, you are not in position. They say, too bad. Why are they teaching them in Nigerian law school? The matter is beyond Nigerian law school. There is need to do an overhaul in our own teaching methods. The way we admit in Nigerian university, the way and manner we teach students in the university. Basically, I can tell you that universities up to this moment, there are universities where students take dictation, they take notes. They refer them to textbooks. But the teaching of our own profession has moved far, far away from where we are today. Why can't you have smaller groups? They interact, do small group presentations, they do feedback, they assess themselves. The reason why they can't do this is because there are too many students. It's a challenge. What is the way out? We suggest every day better condition of service for teachers. Yes, somebody was talking about big lawyers coming to teach. I can assure you, if there is good condition of service for visiting adjunct lecturers, a lot of senior advocates will go to universities and law school to teach. There is need to improve our own libraries. Then there's need for continued review of curriculum in Nigerian universities. Not merely because you don't CC Mass for 10, 15 years, you don't review. Like I've said, the matter is not also reviewing this CC Mass. Who is going to review it? Is the dean democratic enough to say, okay, let's have a participation. Let's talk to our elders. What areas of law currently been special areas of law that we need to bring into our own curriculum? So these are some of the issues. Then there is also need for closer engagement between the Nigerian universities, Nigerian law school, and the legal profession itself. The legal profession is the end user. There is need to ask them, what kind of students do you need? Merely producing law graduates, the time has passed long, long ago. There is need for specialization. Every university, wherever you are located, you should be a specialist in your own area. Rather than saying, we are graduating 100 students, none of them is a specialist. The era has gone long, long ago. Then, need also to, which is closely connected to the issue of funding, is provision of teaching facilities. Yes, like we've said, information and communication technology, people have been hammering that is the new savior, contrary to what we've seen on ground. In the Nigerian law school, if you go to the classes now, while the lecturer is teaching at the back, we call them backbenchers. They sit down on their own handset, doing Twitter, Facebook, WhatsApp, Instagram. Rather than using it positively, doing research, looking at terminologies, what is happening in other jurisdictions, they are busy sending pictures and whatever. At times I take my time to go behind the classes. I'll stand behind them for like 30 minutes. They're unaware of their own even environment. This is a challenge. Rather than using information and communication technology as a tool for research and teaching, they are using it for something else. So I don't want to make much comments here. Then, like I've said also, the issue of teachers is a challenge. Too many teachers teaching. I don't know whether we are teaching what we have been paid to teach or we are teaching what we are not paid to teach. It's a challenge. As teachers also, we need to talk to ourselves. Either we remain as teachers or leave the profession. A lot of us are practitioners. 99% of our time we're somewhere pursuing briefs rather than being in the classes. We are paid to teach, to mentor, to interact with these students. Sorry, I'm saying this, Prof. Okay, thank you very much. There's also need for training, not only training, and retraining also. Like I've said, teachers cannot give what they don't have, no matter what. Merely because you train somebody is not enough. There's need to retrain, to give him the tool. They need laptops, they need databases to work with. So these are areas that we are looking at. I've said about the issue of dressing, issue of poor communication skills by students coming to law school. Then I've also said there are fewer teachers. Every day new universities are established, yes, with the hope that there will be more teachers. Teachers, we're also not sincere to ourselves. You go on accreditation to a university, you see somebody who tell you, sir, I left my last university 2 months ago, I'm here. That's not true. We've told them, we'll activate the power of the LPDC. Anybody who is lying, who has gone to work in a university on license, let's withdraw his certificate as a lawyer. These are things I think we should do. I don't know how many minutes I have, Chairman, sir. How many more minutes, sir? 9 seconds. I'm supposed to look at the issue of pedagogy. How do we teach in law students are unlike other disciplines. We need to have a student-centered learning. These students, they don't finish degree or law school and go back to their homes and sleep. They are going to utilize this. It's practical in nature. So what do we need to do? Students-centered learning. There's need to have small classes. There's need for them to do case studies. There's need also to do feedback on within themselves. This is fundamentally lacking in the universities because of the number of students and staff-students ratio. It's a major challenge. The era of coming to class to give lectures, to ask students to go and read books. So basically, the methodology employed in other professions cannot work for our own profession. That's the reason why we're talking about teacher training, about giving teachers the tools and resources for teaching and learning, also the students themselves, because there is need for them. For example, when we said there should be feedback between themselves, students should have more than laptops, they should have access to databases, they should have access to information and communication technology, they should have access to internet at every given point in time. Then use it also for that purpose rather than going to do Twitter and other things. So on the whole, what I'm going to say is that the issue is beyond what people think. It's not like law school does not do its own job. We're also being confronted with challenges from the Nigerian university system, from our own polity as a nation, for our poor funding of our university system. So we are doing the best we can within the limited resources. But I can assure you, we know the expectations from our profession. We'll continue to do the best we can. We'll teach, mentor, and those also, we can only allow those who think are fit and proper to belong to this profession that will allow them to be here. Thank you very much, distinguished ladies and gentlemen.
Thank you very, very much, Professor Isa Chiroma, Senior Advocate of Nigeria, DG of the Law School. Extremely grateful. We've had a wonderful session, very inciting presentations. And I'd like to commend the leadership of the section of legal practice on what they have done. They have given some of us the affirmation of faith in the quality of brains we have at the Nigerian bar. I say this because I have been pained in the recent past when I see our CLE bringing pupil counsel from the UK to come and do CLE for Nigerian lawyers in arbitration. I've been very pained. We have sufficient good quality lawyers in Nigeria in every field of legal practice, and I'll urge the president of the bar to look into this. Secondly, I want to commend you again because we had an ugly practice where the bar was becoming personalized in those days. When you go for functions, you see the picture of the chairman of the section taking half one big banner. And again, I am seeing that trend creeping up in Institute of Legal Education, where whatever program we have, instead of highlighting those who are supposed to be presenting, the chairman of the session, his picture must be there. It is condemnable. The bar is for all of us, does not belong to any person, and they should please stop that practice. When we have something to do, we should do it understanding that we are serving the bar. Finally, for this section, this issue of cross-border practice has been touted for a very long time. And if there's any lawyer here who has been briefed by a company out of Nigeria to represent them in a litigation on arbitration outside Nigeria, I would like to know. Because what I keep seeing in this cross-border discussion is how counsel from other jurisdictions can come and take the little work that we have here. And we should look at it very carefully, look at what happened to the accountants in deciding the way forward. It is good for us to open, but is there reciprocity? What are we doing? There's still that colonial mentality that the black man is not good enough, which is why I said I was pained earlier on when I see them bringing people to come and teach even arbitration when we have more chartered arbitrators. When I became a fellow of the institute and I went for my peer review interview, it was being done by a Nigerian in the UK. So please let us get these things right. We are pained and we never had the opportunity to express our pain. So permit me if I have deviated a little bit from the theme of your conference, but I just thought that I should make this position very well known. Thank you very much. We have received questions from 3 people, and I think Osagie Oikena, our own Chief Mrs. Olivia Agbajo, and I believe one more question from Lekon Bade John of Lagos branch. I'll give this question to, see, it talks about retired judges, so I'll give it to Taiwo Taiwo. You just please answer and then give any closing remarks that you have. Thank you very much. We'll be out of here in exactly 3 minutes. So our lead presenter should go first, please.
Thank you very much, Mr. Chair. So the first question is from Mr. Osagie. Asked 2 questions. The first is that under the Delta State Administration of Civil Justice Law, where a lawyer causes delays, he pays 100,000 what should be the statutory sanction for judges who cause delays? Secondly, a huge number of cases are taken out of high court judges, are taken to the tribunals, occasioning delays. What is my position on this? Okay, so on the first one, as a functional matter, judges exercise punitive control over counsel, but not the other way around. So who would enforce it if you impose a punitive sanction on a judge? That's the first. But secondly, I understand where you're coming from. And what we tried to do in the Delta State law was to minimize the chances of a delay causing event. So primarily, each party in the case has to nominate something called a case representative that monitors the progress of the case and ensures that each direction of the judge has been complied with so as not to occasion a delay on the next adjourned date. The judge or the court also has to appoint a case representative that will inform the parties if there are any occasions or any events on the court's part that will stop the case from going ahead on the next adjourned date. So there's a constant communication between all the parties to collaboratively manage the case. Secondly, if in the event that the court actually causes a delay, again, there is a statutory function, but that function is to make a compulsory report to the Honorable Chief Judge. So the Chief Judge is monitoring the performance of each judge. And we think that in and of itself is a deterrent factor in and of itself. On the election petition issues, I agree with the observation of my Lord, the Honorable Justice Taiwo retired, in that we should perhaps consider appointing retired judges to constitute election cases, but that will require quite a number of constitutional and statutory amendments to occasion. In the current state of affairs, it's not ideal. The best you can do is to foster a change in thinking so that I've seen, for instance, many cases that should not be before the election tribunal go in there for the fear that one's political supporters will think you have sold out if you do not file a case. So that needs there's a change of mindset needed there, in addition to whatever innovative statutory changes we want to bring. Chief Agbajo asks, the Delta State ACJL 2022, why would the law recommend committal to prison for a lawyer who defaults on the management of a case? Is this not too harsh? So the ACJL 2022, which is our criminal justice law, doesn't actually make that recommendation. You may be referring to the civil justice law, which has something called a procedural caution. The procedural caution is issued by a judge as a very last resort if there has been repeated breach of a procedural order from counsel. And again, it falls under the judge's punitive control over counsel. So it in effect amounts to contempt of court, where you are not complying with the order. So if there's a repeated breach of a court order, the court can issue a procedural caution. If you breach that caution again, then you will be subject to that punitive control. So it's not automatic, it's a last resort. I hope that answers your question. Otherwise, during the lunchtime break, I'm happy to take any further questions.
Thank you very much. Justice Taiwo.
The question of Mr. Lekon Badi John has been answered in part by the presenter of the paper, Mr. Isaiah Bozimo. And all I just have to say is that, yes, the NBA, just like any interest body, can sponsor a private bill to the National Assembly to make all election petition matters to be handled by, in quotes, willing retired judges. Yes, it's possible, but I think the NBA will take the lead by just setting up a committee to look at all the laws that are meant to be changed, and of course, it is constitutional too, so we have to look at that. Thank you very much. Please.
Thank you.
I should keep it.
Justice Taiwo. We want to thank you very much. We've had a very good session, very interactive audience. I'd like to recommend the Doctor of Doctors, Dr. Yemi Johnson. I believe he has a session coming up soon. And I'll urge all of you to wait and listen to him too. I will try and wait and listen to him. We hand the session now to the session coordinators for the closing formalities. Thank you very much, and God bless you all.